This is the first time in the Federal Republic of Nigeria that I will see blatantly, koro, eyeball to eyeball, that an armed robber will be accusing an innocent citizen. I mean, a man who has criminal tendencies, a man who is a convicted criminal by the virtue of money that was confiscated over 340 million naira was confiscated in Tinubu's account as a drug lord in.
Guys, I want to show you the depth of the current wickedness in our judiciary. You know, a lot of you are saying our judiciary is corrupt, but it was corrupt before, right? Let's say under Obasanjo, let's say under Goodluck Jonathan, to some extent, our judiciary was corrupt, right? But under the drug baron we currently get as president, please watch this video to know the level of wickedness in our judiciary. As it stands, guys, it's as good we don't have electoral body INEC. It's as good we don't have judiciary anymore. Okay, but before, please watch this video to the end though. It's very it's an eye-opening video. Now, before I show you the video, permit me to show you a video of Dino Milaye where he gave it to Pablo Escobar T-Pain water. This is called water reason. I beg, as you watch this video, just share it. T-Pain will never forgive Dino Milaye for this. No, he's not going to forgive her. Guys, please give this a thumbs up. Share it in all your platforms. God bless you.
This is the first time in the Federal Republic of Nigeria that I will see blatantly, koro, eyeball to eyeball, that an armed robber will be accusing an innocent citizen. I mean, a man who has criminal tendencies, a man who is a convicted criminal by the virtue of money that was confiscated over 340 million naira was confiscated in Tinubu's account as a drug lord in America. And not only a drug lord, is even a suspected addict of same drug. A man who faced code of conduct for criminal activities. A man who have over a dozen of petitions waiting for him in the FCC and ICPC. The man that is supposed to be arrested and prosecuted is the one that has been indicted already of being a drug baron, and there's a certified court indictment that money was confiscated, money was taken away from him to the tune of 340,400,000 naira, to the tune of $460,000. That is already an indictment. Is the man that has faced code of conduct before. Is the man who bled Lagos to nothing. Is the man who is using Alpha Beta to destroy the economy of the poor citizens of Lagos State. Is the man who has taken over all the properties of government in Lagos State. Even TVC is what used to be the property of Lagos State. His house in Abuja used to be the property of Lagos State. His house in Babylon used to be the property of Lagos State. That is the man that should be indicted. The man whose wife is supplying the diesel to all government offices in Lagos. The man whose son is in charge of designing this in Lagos. Senator. That is the man. The Constitution of the Federal Republic of Nigeria have said to you, for you to be the president of this country, you must be physically and mentally fit. Tinubu is not physically fit, he's not mentally fit, and he has been indicted of a criminal activity in America where over $460,000 have been confiscated from his account. We have evidence of his criminality. We have evidence of his indictment.
Where somebody came to show me about one write-up where they said there's one professor that wrote. I asked him, professor of which university? Nobody knows. But it's a professor. They say it's a professor of law. Where has he taught law? Nobody knows. Where has he advocated law? Nobody knows. But it's only a professor of law in social media. They had the opportunity. They were given the opportunity in Human Rights Commission. Ask them, what was their performance? What was the record when the government gave the opportunity to be there?
Wike can't take half of what he dishes to others. Professor Odinkalu only stated facts. He wondered why the Chief Justice attended the breaking of sword on a land that Wike took from Julius Berger. So if Julius Berger is going to go to court to reclaim their land, who will determine it? That's the same Chief Justice that attended the breaking of sword. So they stand no chance in getting justice. He wondered why she chose to attend the event, that she shouldn't be seen to be mingling with people or politically exposed persons that could be potential litigants in the future. The judiciary arm is supposed to be independent. Even if they are not, they are supposed to create that impression in the minds of Nigerians so that they can continue having the confidence that they can get justice without knowing anyone, without having to bribe any judge. And in response to Wike's insults, Professor Dinkalo called him a greedy glutton that is binging on public funds. He also spoke in an EXP0'S hosted by Mindset, where he went back in history narrating all the problems faced by Nigeria's judiciary, that they are not independent. It's an interesting work from the prof. Also, another colleague added his voice on the rot in Nigeria's judiciary. Let's take a listen.
I think it's plainly absurd, and that's putting it mildly, that the Chief Justice could sit in that encounter. And, I've heard people like OCJ Okocha, the former president of the Nigerian Bar Association, who actually was Attorney General of Rivers State at around the time that Wike was coming to the Nigerian Bar, and who now is dancing on your mandate we shall stand to the same Wike singing it, right? And I've heard OCJ, defend the kind of thing that the Chief Justice did. So let me try and explain, because OCJ has claimed that he is an eminent lawyer. I personally, he's over 70 years old, and as a former president of the Nigerian Bar Association, I've got to have some respect for that. I also, because I have respect for that position as a former president of the Nigerian Bar Association who is over 70 years old, I have got to say that I'm worse than disappointed that a 70-year-old senior advocate with over 30 years experience as a senior advocate can be twerking to "On Your Mandate We Shall Stand" being sung by a man who has never gone to court. I don't owe him. The only thing I have to do is a duty of my own truth as a citizen of Nigeria. Anyone who is not disappointed by that has to have something wrong with their values. And so I also take, therefore, with a pinch of salt, the views of people like OCJ, who are quite clearly, in my view, in the payroll of Wike. Now, having said that, let's understand this. The Chief Justice went to the turning of the sword on a judicial housing project by the Minister for the Federal Capital Territory, right? Now, judicial housing cannot be done by litigants who come to the court. And the FCT High Court, the FCT as a government has to sue before the courts, and their cases go up to the Court of Appeal to the Supreme Court. When those cases go up, they are parties. And if they are parties before the same judges whom they are housing, there's a problem. That is why the judiciary is an independent arm of government, and the judiciary has always awarded its own contracts. Court of Appeal headquarters was built by judiciary. The Supreme Court was built, judiciary does its own procurements. That's why they established the NJC. Okay? Now, we have this orgy of people in power across the country. To be honest, it's not Mr. Wike only alone that does it. All of them do it. And my position has always been the same, right? And the judiciary has been acquiescent in this practice of being compromised manifestly by people who litigate before them. And I've got to give the example of JIC Taylor, John Idowu Conrad Taylor, who was the Chief Justice of Lagos State, because at the time he headed the Judiciary of Lagos State, he was the first Chief Justice of Lagos State. He died suddenly in 73. JIC Taylor, in 71, shortly after the war, was invited by Mobolaji Johnson to a party, a reception for the head of state, to accompany him to receive the head of state who was visiting Lagos formally. And JIC Taylor declined that invitation because he said he could not afford to be seen in that kind of situation with potential litigants in his court. Two things happened in this particular case. Number one, the Chief Justice, or three things. Now, the Chief Justice went to this thing with an active litigant before her court. That's number one. Number two, the building itself, the process, the entire construction is being done by an active litigant before the court system that she heads, and with cases, who has cases before the Supreme Court as we speak. Number three, at that event, even if she didn't know any of those things and she didn't consider any of those things, at that event, Wike himself told the story of how he expropriated the land with no notice, contrary to the requirements of the law, the Public Lands Acquisition Act, right? With no notice, and in fact, the Land Use Act. He has the powers, yes, but you've got to give notice. He told the story that he invited the chairperson of the board or chief executive of Julius Berger to dinner, and the following morning sent them a revocation letter. The Chief Justice sat there quietly, said nothing. President of the Court of Appeal sat there quietly, said nothing, and they could not find the legs to walk out without doing anything. That for me says a whole lot. I don't even need to use adjectives. Just describing that alone tells me a whole lot about the judicial values of the people who run the judiciary. And that, to say that that is worrying, is an understatement.
This issue that we're discussing is not new to me. It didn't start today. We've been in this field for a while, playing the game. Prof is also not new to this. It's not like he started doing it because of any individual. No, he's been in this for a long time. At a time, we've been pushing even for the scrapping of the rank of senior advocates because it is an anomaly. It reduces some lawyers, so there is no equality before the law. As you know, if you go to court, you're not an SAN, and an SAN is there, he gets to do his case before you. So his client has more access to court than your own client. So there's no equality before the law. Now that's an issue for another day. The judiciary have now managed to colonize that arm of government. It belongs to them. It doesn't belong to the people. So they don't owe the people any explanation. And that is why the judges can do anything they like. And Nigerians too have given up. They treat the judiciary like it is not our property. Let them do what they want. It is not correct. These judges ought to serve us. They ought to be responsible to us and be responsive to us. I have been stung by the very scorpion that I've been trying to kill for a long time. Some years ago, Prof and I, with some of our colleagues in the Open Bar Initiative, wrote to the President Buhari, and we stopped the appointment of judges who were children, girlfriends, PAs, and all sorts of judges and their cronies. And Buhari stopped that appointment, and people insulted us. Some were happy with what we did. But do you know that 2 years later, they did that appointment secretly without any public advertisement? The same people that we stopped, they are all judges now. If we appear before them, what do you think they will do to us? One of them the other day, she's the daughter of Mary Odili, saw me on the High Court. And you see the kind of eye she looked at me, like if you have a gun, you shoot me. Nobody is doing this because we hate the other. We're doing it to move this nation forward. Our democracy today is where it is basically because of the judiciary. If the judiciary can rise up, INEC would not rig election because they know it will be reversed or cancelled and they will have to repeat it over and over and over again. But today, INEC will try to do a good election. When the politicians hijack it, INEC will help them compromise it eventually and the court will come and seal it. Do you know that as a petitioner, in election petition, you are laughed at by the judges, you are laughed at by the respondent counsel. They laugh at you. So it's as if you're coming there to waste their time. They frustrate you. This is a case I filed when I ran for Senate. Clearly in the petition, you could see I was talking of beavers. I pleaded it, but the tribunal said I did not plead beavers. What kind of illiterates were they? Couldn't they read? We went to the Court of Appeal. They said, see, he pleaded it in all of these places. And that was what Prof referred to, that the interlocutory appeals, the Court of Appeal seemed independent. But then, when we concluded that case, we went on appeal, and the panel that was hearing all the interlocutory no longer was competent to hear the main appeal. They removed 2 members, senior judges, the presiding and one other, and brought 2 from outside. The moment some senior lawyers and even justices of that court heard that the son-in-law of the president of the Court of Appeal is in that panel, they told me, oh boy, forget it. The woman has interest. Anywhere that boy is, she has already secured something. That was the word. So I didn't bother myself. But we went through. And the judgment, because I'm a lawyer should reasonably know a case he will win or lose. What do judges do? They apply facts to law. It's not magic. Now you see a Court of Appeal deliberately misquoting the Supreme Court on what is a public document in a case where the Supreme Court said that a letter written by an individual in his hand is a private document. But if he submits that letter to a public institution like the police, that letter becomes a public document. Even copies made from it are public documents. This Court of Appeal said, no, that judgment said he can keep a copy as private document. That is a lie. I had to go back and read that judgment in case I didn't understand what the Supreme Court. I read it over and over again, and I saw that they were just struggling to defend nonsense. And because you can't go to Supreme Court to try again, it becomes dangerous to leave the Court of Appeal, which is perhaps the most corrupt court, competing with the Federal High Court now, to be determining all of our houses of assembly, our House of Representatives, and Senate, because that is what they do. The president of the Court of Appeal has the sole discretion of setting up tribunals, including for legislative elections. And then she set up panel to hear appeals from those tribunals. So she can determine your fate even before you file your petition with proper arrangement. That was what happened to me. The arrangement was solid. Even before I filed my petition, my fate was sealed. So we cannot say we are doing democracy and then we have some judges playing ping pong with our laws and with our emotions and with our courts. We put them there. The outrage must be there. I thought that Nigerians would go out and say, Monica, you must resign after those stupid judgment they gave in Plateau State National Assembly and House of Assembly cases. That her son-in-law was in those panels, and he was just appointed last year into the Court of Appeal. She brought him into the Court of Appeal for the things she wants to be achieving. We cannot allow a judiciary where people with integrity are not qualified to be judges. Most of our judges today are people who have failed in their private practices. They have failed. They got to the bench in order to be earning salaries. So they didn't go there because they are passionate about the job. They went to earn salaries. That is why they will throw themselves over to fight for slot to hear the cases of anybody who pays them. And they don't care about you because for them, they are there to make money, not to serve. Judges who are there because they are passionate about that job hardly make it to any of these celebrated corrupt cases you hear. They can't even, it won't even come near them. How do we deal with these things? I have written a whole topic on judicial reform. Our judiciary, as presently constituted, for the Federal High Court, for the State High Court, High Court of the FCT, is okay. it is okay if we will follow the constitution. Like I said, they didn't transition to democracy. The intendment of the 1999 constitution is that every judge will be appointed from among legal practitioners. From among legal practitioners, including a chief judge. There is nothing like the most senior judge becoming chief judge or chief justice of Nigeria or president of court of appeal. Go and read the constitution. They are to be appointed from legal practitioners. The constitution only made exception for acting capacity. When the chief judge's office is vacant, you bring the highest, the most senior, to act until a replacement is appointed. But they have cornered it into their own. They elevate themselves when each court is independent of the other. Your employment as a high court judge does not qualify you to go and jump into court of appeal. It's a different court. If you want to go to court of appeal, you apply as a lawyer, 12 years post call, you go there. Supreme Court, 15 years post call, you go there. High Court, 10 years post call, you apply. So that now the process of recruitment will be something we all monitor. MBA will be part of it. Remove this NJC nonsense because it's just a charade. They go there to gist. Olumide Apata told us they don't punish anybody. Because he told us they hate him. He's one of the most hated past MBA presidents because he exposed them. Forget about NJC. It needs to be reformed thoroughly. Judges have no business being in NJC. Ordinary reasonable man should be in NJC so that reasonable man standard will be used to reassess judges whether they are performing or not and kick them out. A judge who is employed as a judge for FCT High Court should know his jurisdiction properly delineated. The chief judge should not assign cases to him. Only cases that arise from his jurisdiction should come to him naturally. And he is in that court until he retires. If it's a problem, people complain and they sack him. Another person is appointed. Today, they just keep appointing judges up and down, left, right, center. You don't even know where they are. Chief judge just keep, okay, let me now save us some time and talk about the last crazy judgment that came up. That Abdul Malik or whatever. I know a senior lawyer who told that woman, she has never practiced before she became a judge. She was working with shipping lines and then finished her job with the shipping lines, came out with money and approached him that she wanted to be a judge. He said, let me see your resume. He looked at it, he said, you have no practice experience. He said, she has hit the EXPOS call and she's ready to pay for it. He said, my dear, you are not qualified. I cannot help you. To his greatest shock, he saw her name in the final list. She became a federal high court judge. Why wouldn't such a judge delve into a matter that is strictly a state high court case? Because we are talking about a state appropriation. It's a state house of assembly law. What has the federal high court got to do with it? Why will the federal high court go and be interpreting state appropriation or decide to now remove a federating unit from Nigeria? Because effectively that is what she has done. That judge is supposed to have been kicked out by now. Nigerians are not angry enough until we are angry about these things, until we show that the judiciary must bend to the will of Nigerians, not their personal interests. We are not going anywhere. And I'm happy we're beginning to have these discussions. I must commend Mindset. I must commend Prof. We need to take it out of the social media and begin to meet physically to address them. We cannot be afraid of them. We cannot say we will not talk because they will stop some benefits coming to us. If they don't give you briefs, go and farm. Fight these people until we get this country working again.